Trump and his defense warn Alvin Bragg this trial is right around the corner, looming on the horizon. We know that it is starting just a few weeks from today, and Trump is now telling Bragg that he is on the verge of committing prosecutorial misconduct. His team sent a nice letter over to the New York Manhattan prosecutor's office, and they're explaining that there is a little bit of a discrepancy. They're wondering why, oh why, in New York, are they prosecuting Weisselberg, former Trump CFO, for perjury, when just not too long ago, Michael Cohen was in New York in trial, participating against Trump, taking the stand, testifying, and admitting to committing more perjury, right? Admitting to lying when he lied or took a plea deal for lying, right? So the guy lies all over the place. But the question is, if he lied in open court or admitted he lied in open court, why is Bragg not prosecuting him? Why is Bragg only prosecuting a potential Trump witness with perjury? And so we're going to get more into that story, get some background on it, and get some legal analysis from Alina, Habba, and some others. But of course, let's dive right into the letter. This is a warning to Alvin Bragg. Todd Blanche sent this over to the New York County District Attorney's Office regarding prosecutorial misconduct. Alvin, concerning Michael Cohen, aka the convicted perjurer. There should be an asterisk by his name every single time, you know, like a steroid user or something. But perjury. And Alan H. Weisselberg, okay, which was Trump's former CFO. And trial is starting very soon on this, and it's a criminal trial for multiple felonies. This is their last ditch effort. They are working very hard to get Trump a felony conviction before the election. And this is the last one. I mean, we know the J6 case because that's on appeal, not looking so hot. Fani Willis has been caught indicting Nathan Wade, you know what I mean? And so that trial is probably going away. And Florida, it's classified documents. You know how complicated those can be. And so that might take some time as well. So they accelerated this one. Judge Juan Mercan said, perfect, let's go to trial. And they are here. Now, Trump is saying, you better do something about this case, Alvin. Don't you dare put Michael Cohen, a convicted perjurer, on the stand, they say. Dear Alvin, we write regarding ongoing prosecutorial misconduct, buddy, in connection with the prosecution of President Trump. This is coming in violation of the federal and the state constitutions and, Alvin, your ethical obligations as well. Why? Well, it concerns your simultaneous decisions. One, which of course is to turn a blind eye to the admitted and repeated perjury of your star witness called Michael Cohen, a convicted perjurer if you didn't know. And two, vindictive and oppressive pressure and plea negotiations that have led now to a forced guilty plea for 2 counts of perjury for Alan Weisselberg. So Trump's CFO, who's on Team Trump, Alvin goes hard after him, prosecutes him for perjury. It's made up, as we'll see. And then Michael Cohen, who just committed perjury, gets off scot-free. Weird. Now, this conduct by you, Alvin, was obviously part of an effort to impact the outcome of the flawed proceeding by Tish James and Mr. Weisselberg's role in the trial. Now, Weisselberg doesn't appear on any witness lists currently in this case, but your conscious choice, Alvin, to ignore obvious and the admitted criminal conduct by Cohen, he says I lied, and instead deploy unethical and strong-arm tactics against an innocent man in his late 70s just underscores the conduct of your office. Now, indeed, Alvin, while you waste public resources in a desperate attempt to impede Trump and his ongoing ascent to the White House, looking better every day, in violation of prosecutorial guidelines that prohibit this type of election interference, you regularly and repeatedly allow those guilty of brutal attacks on law enforcement, like illegal aliens and murderers, to roam free around your city. And so this dereliction of duty renders you fully unfit to serve, and it exposes innocent citizens like Mr. Weisselberg to irreparable and life-altering harm. They say, all right, Alvin, let's get into it. They say, today, your office has forced Mr. Weisselberg, a 70-year-old man, late 70s, almost 80, into pleading guilty to non-existent perjury offenses, and you threatened him with years in state prison if he did not succumb to your demands. It happens all the time, okay? Prosecutors come in, they say, well, here's what we have. I mean, it looks like you said this, and you said this in trial, and we have this other statement here, and we think it's a lie. So I didn't lie. I just meant this, and here I meant that. Well, it's not what we say. And we say this has a different meaning. You intended that this was a lie. He says, I didn't though. They say, well, since you've already pleaded guilty to another crime, and now you'll be like a repeat offender. And so now, since these are felonies, obviously perjury is a big deal. You lied in a major trial here. So if you do get convicted of these, which of course you will, because this is New York, and everybody who's even remotely associated with Trump is going to get convicted in New York. So why don't we do this? Rather than you going to prison, which is mandatory, by the way, they'll say these are 2 dates of offenses plus this one. So you are mandatory prison, or you can just take this plea deal. We'll just add a little bit more probation to your current offense. What do you want to do? He goes, goes, obviously, right? I don't want to spend the rest of my life rotting away in prison with Tish James tweeting about it. So I'll take the deal. Thanks. Happens all the time, all across America, every single day. Probably to people that you know and love too. Prosecutors threaten them because our laws are, oftentimes have mandatory minimums, and they're very difficult to win, especially in a political prosecution like this. What is he going to do? So they force him to plead guilty. Okay. So now when this trial starts and any references about Weisselberg or Trump's CFO or how the money was moved around, because this is the Cohen case, they'll just turn around and say, oh, who? From the perjurer? Oh, you're going to believe Weisselberg? He pleaded guilty to perjury, right? So they are tarnishing a potential witness, even though apparently he wasn't on the witness list as it stands. So Trump's team continues. As we understand it, your loser prosecutors, my word, presented Weisselberg with an impossible choice. One, plead guilty to perjury crimes that he did not commit in exchange for another relatively short stint in prison, or face arrest and incarceration, and risk that an unsuccessful effort to fight these unwarranted charges will result in yet another draconian sentence by Judge Juan Merchan. Indeed, to compel a plea today by forcing him to do this on drummed up charges on which a jury would never convict, we understand that you threatened to file a sham indictment against Weisselberg and then to immediately ask Juan Merchan, the judge, to violate him, who's on probation. Oh my gosh, that's even worse. Risking further jail time even though he's in fact innocent of any crime. So Weisselberg is on probation for, he pleaded guilty to something else, right? And it was another finance charge, right? They were trying to nail him to say, oh, parlay that into Trump. But if you're on probation and you commit a new crime, well, that's a huge problem. Obviously, you're on probation. You're not supposed to get in trouble again. So it's almost always immediately revocation of your bond, or it will be something that you could be arrested for and held back into custody. The judge could say, well, you were on probation. I told you not to do it again. You're not getting out this time. And now you got to deal with both crimes, the new crime and a probation violation on the original crime, because you violated your probation by being charged. Like, it's a new crime, right? It's a probation violation, theoretically. So it spirals pretty quickly. So they hit him with that. You better take this plea. If not, we're indicting you. And even if you think you're going to win the indictment at a jury, you're still going to jail for a while now. And Juan Merchan might keep you in there because he's Juan Merchan. But again, this happens all the time too. Now, such tactics have no place in our American justice system, and you should be ashamed of yourself and alarmed of this tyrannical conduct. It's like, oh, well, that was their entire thesis. They woke up plotting this. How do we take out more people on Trump's side? We got one attack with Weisselberg. So by contrast, so that's what they did to Allen. Let's talk about what they did to Michael, a convicted perjurer called Cohen. By contrast, Michael Cohen admitted to multiple instances of perjury, and then he committed perjury in open court back during the Tish trial, including by trying to walk back sworn federal guilty pleas and mischaracterizing his interactions with those federal prosecutors. So Cohen said that he lied to the federal judge, right? So you said that you lied to Congress, right? That's why you pleaded guilty. Yeah, I said that, but it's not true. Wait, what? So you lied about admitting to lying. Is that true? Yes. Okay. So you lied about admitting to lying. Are you lying now or not? Nobody can tell. So at the February status conference back in the Tish trial, DA Colangelo essentially confirmed that the district attorney, Alvin's office, is not investigating these blatant violations of New York law. In essence, he asserted to Judge Juan that the only appropriate remedy for perjury by Cohen in a New York state proceeding is for Trump to cross-examine Cohen. That's all. And so we appreciate the tip, and we'll be sure to add this to our cross-examination outline near the questions about the gift that the New York attorney's office gave to Cohen by not charging him with the same, quote, crimes charged in the indictment against Trump. So in other words, Cohen is getting off scot-free, right? He lied. He admitted he lied. He broke the law again in court, and the entire court system, including the judge, are just like, well, cross-examine him. Now, your office, Alvin, warmly embraced Cohen, the liar, and doubled down on this position in February. You opposed Donald Trump's motion in limine, which we covered here, saying in that filing, the DA's office also endorsed this ridiculous finding by Engeron. Remember Engeron, Areola, aka the Nip? He came out, he said, Michael Cohen told the truth in my courtroom. Then he took his shirt off and was credible at the People versus Trump trial. That's the Tish trial. Engeron's findings as to Cohen's so-called credibility, they were made despite perjury by Cohen that is more central to the proceedings than the sham trial that Engeron himself facilitated. So Cohen on the stand in the New York trial was like, yeah, I lied. I lied about lying. And Engeron's like, wow, that was really good testimony. So honest and truthful. I love you. The reality is the opposite. Engeron is obviously wrong. But whatever the merit of Engeron's flawed views, if you choose, Alvin, if you choose to put Cohen on this case, that decision is going to have serious serious legal and ethical consequences for the integrity of these proceedings and for individual prosecutors who would choose to suborn Cohen's perjury. You're going to put him on there and make him lie? The New York rules of professional conduct say you're not supposed to do that. It's prohibited, saying to do so would be unethical and actually illegal, by the way. And it would also be a clear violation of the DA's, quote, special duty to seek justice, not merely to try to convict. Yeah, but that only applies for people who are not Trump. Now, the inclination, Alvin, of your office to look past the grave problems of Cohen's perjury and his credibility that was suggested in your filing is even more egregious. So he responded to Trump's motion in limine. So Trump said, Michael Cohen, judge, like he should not even be allowed to testify. The dude is like a liar, bona fide. And then they responded and said, well, if you think he's a liar, why don't you just cross-examine him? Just ask him questions about that, which is kind of the normal thing to do, except this dude admits that he lies to federal judges. You know what I'm saying? So it's not really reliable. So they say, you said it's not a problem. We love Michael Cohen. He's honest. Engoron said so, and should be completely unacceptable to anyone who's concerned about the limits of prosecutorial discretion. Now, when considered relative to your office's treatment of Weisselberg, which we're going to talk about below, saying the selective prosecution of Weisselberg, so he gets a fake perjury charge while Cohen does cartwheels, mocking justice, is an affront. Cohen has not been prosecuted for any of the crimes that you allege against Trump, and he faces no consequences as a result of having his admitted and recurring perjury. And remember that Cohen was also allegedly facilitating all of these crimes that they're trying Trump for. Like, Cohen did it all. He's going to be their witness. I took this, I moved this, I did whatever. Now, by contrast, in 2022, the DA's office improperly relied on unlawful leverage by Judge Mercan Wan to order to pressure Weisselberg to plead guilty, admit to facts that he disputed, and adopt your preferred narrative, and cooperate in the Trump Corp trial. Now, as you know, Judge Wan's failure to recuse himself from that case, despite his participation in those shameful negotiations, is currently on appeal. Now, as with suborning Cohen's perjury, individual prosecutors and their facilitation of Juan Mercan's handling of the plea negotiations has serious ethical implications. Saying, Alvin, just so you know, there is deep irony in all of this, with due process implications. If you decide to pursue a perjury case against Weisselberg, which you have done, during the same time where you're refusing to even investigate Cohen's admitted perjury at the same trial. Okay, so two guys come out of this one trial. Fake prosecution for Weisselberg, no prosecution for Cohen. Weird. Now, we understand that Weisselberg is serving a term of probation because he took a guilty plea in 2022. However, Cohen was also serving a term of federal supervised release because he committed perjury and pleaded guilty to that. Now, the terms of Cohen's supervised release require him not to commit any more crimes, and we recognize that you're not in a position to pursue a violation of supervised release, and we are concerned by the failure of the federal probation authorities to do so. However, Alvin, your cynical inaction with respect to the violations that result from Cohen's perjury are also problematic, and even more so with the callous and vindictive approach that you've taken towards Weisselberg. Now, your inaction with respect to your so-called star witness, while actively pursuing an unfair and unwarranted plea from Weisselberg, cannot be a resource issue. 9 prosecutors proudly signed the filing on your behalf and in support of Cohen. So we are left with the impression that there must be some other motivation, I wonder what it could be, to drive your decision to put Cohen on a public pedestal, say this is an honorable person, when he is actively monetizing this whole thing. He sells a completely fabricated story to the public on his stupid X account as you seek to reincarcerate a 76-year-old man called Alan who poses no threat to anyone, all while New York is rampaged with violent crime rates impacting everybody on your watch. Now, whether that is a part of a coordinated effort with Tish James to enhance her position in the Trump case, or whether it's a strategy to impact Weisselberg's role in this trial, your corrupt tactics are improper and they are contrary to the basic principles of decency. And we urge you to reconsider as to both Weisselberg and Cohen. Not going to happen. So they give us some more background here. They tell us, during the People versus Weisselberg, the prosecution team insisted that he go to prison, and he cooperated and even provided helpful evidence if he helped, but he didn't. When he resisted that approach, you then sought Juan Mercan as an arm of the prosecution, suggesting that Weisselberg's attorneys meet with the court. So then Weisselberg's attorney met with Judge Wan. During the meeting, Wan indicated that unless Weisselberg cooperated against Trump and the others, he would only offer Weisselberg prison. Wow. So they did what's called a settlement conference where they brought him in and they said, well, yeah, I mean, Juan Mercan, the judge, said, well, if he comes before my court on these charges, I'm probably going to give him prison. And they said, well, Judge, is there anything we can do to avoid a prison sentence? And he says, well, there are certain things in the statute that might help. One of these is cooperation with the government. And they say, oh, okay. They go back to their client. Hey, they're going to throw you in prison unless you cooperate. That's what the judge told us, right? And they say, oh. So in other words, he adopted Manhattan's position. Same judge. Judge Wan also stated that if Weisselberg went to trial and was convicted, he would sentence him to a longer prison term. So this judge, these judges are just the worst, is going to give him a trial tax. If you exercise your right to trial, you get taxed for that if you lose. Judge Wan stated further that he would remand Weisselberg as soon as the verdict was returned. You go right into custody and deny bail. And this dude's 76. So in short, Wan indicated that the only way to avoid serving time behind bars was if Weisselberg cooperated and pleaded guilty. That's your justice system in action, right? We think we live in a system and a society where people and witnesses aren't pushed into doing things. We watched right there. And that's absolutely, in my opinion, true. I believe that absolutely happened because I've been in the rooms when it does happen. I've had judges tell me that. Well, you know, your client. So Mr. Weisselberg and his attorneys, they agreed to talk to Manhattan about whether Weisselberg had truthful information. However, it became clear that he did not have any information that fit the DA's preconceived version of the facts, right? So Bragg says, here's what I need from you. I don't have any of that. And so they sent Weisselberg's attorneys, they sent the judge a letter. They said he didn't give them what they wanted. So then Weisselberg's attorneys and Judge Wan, they met in connection with these plea negotiations. Now, during a meeting with Judge Wan, Alvin suggested that it would recommend a sentence of 6 months prison for this guy if he would plead guilty, adopt a detailed factual allocution, which is like a recitation of the facts. So Manhattan writes it, and then they're going to say, do you agree to this? And he says, yes, I do. Alvin agrees. Yes. Okay. So agree to testify against Trump and agree that the sentence would be held in abeyance until after the trial. So then the judge said, I'll give you 5 months jail terms. I'll give you less jail if you do everything that Bragg wants, holding jail over a witness's head. Typical. Now, on the afternoon of August 17th, Judge Wan then met with Manhattan and Mr. Weisselberg, and he confirmed the plea allocution. It's a recitation of the facts. Now, the next day, Weisselberg then pleaded guilty to a series of felonies, including tax fraud. At that hearing, Wan questioned Mr. Weisselberg using the allocution. Wan also told Weisselberg that if he did not comply with the terms, he would impose up to 5 to 15 years in prison. So you can see how testimony starts to change, right? You know, now you do all of this deal, and then they say, well, we need you to, do you have this information? No, you don't have it. Well, what if I go tell the judge? Whoa, you're going to tell the judge I don't have the information, or I'll tell the judge you're not being cooperative. Boom! Now you got a prison threat dangling over your head like the sword of Damocles. Mr. Weisselberg testified in the Trump Corp trial over the course of 3 days in November 2022. And on January 10th, Wan sentenced Weisselberg to the 5 months in prison and probation. Now, according to the New York Times, almost a year later, Manhattan contacted Weisselberg's counsel about an alleged perjury that came out during testimony. Now, we necessarily lack detailed information about those negotiations, but as we understand it, Mr. Weisselberg was met with 2 unfair options. They came back at him. They said, either you plead guilty to perjury in crimes you did not commit in exchange for another minimal prison term. So we'll add a little bit more time. But if you refuse this, Alan, to this new perjury charge that's made up, you will be promptly indicted. And then you're going to have him jailed for a probation violation. And you're going to take a senior innocent man, you're going to make him suffer in jail, waiting on a hearing on an alleged violation of probation, which has a very low burden of proof. So obviously that'll stand. And then if Weisselberg is unsuccessful fighting the probation violation charge, the new charge, it would then result in a sentencing before Judge Wan, who has already promised to send him to jail for several years in that event. And so, of course, what did Weisselberg do? Of course, he pleaded guilty. He went down, he took perjury in the first degree. He said, I'll go to prison for 5 more months. And then he appeared before this judge, Lori Peterson. Now, apparently, despite Juan Mercan's role in the negotiations, it appears that Weisselberg will go 6 weeks in, not 5 months. There's no publicly available information as to why, after improperly selecting Juan to preside over all of the cases, why he is not presiding over that perjury prosecution. So what happened there? Very curious question. Says, okay, now so that's Alan Weisselberg, right? They went after that dude hard for no reason. But let's take a look at what happened with Michael Cohen. Remember that Michael Cohen is a convicted perjurer. On August 21st, 2018, Cohen pleaded guilty to 5 counts of tax evasion and 1 count of false statements in violation of the law. In his allocution, Cohen accepted full responsibility. Remember this? The defendant, Michael Cohen, here's what he said. Your Honor, in the tax years of 2012 to 2016, I evaded paying substantial taxes on certain income I received that I knew was not reflected in the return that I caused to be filed. He's reading. On or about February of 2016, in order to be approved for a HELOC loan, a home equity line of credit. I reviewed an application form that did not accurately describe the full extent of my liabilities. I did not correct the information on that form. Judge walks up, chimes in. Well, you knew it was false, that it falsely depicted your financial condition, didn't you? Yes, Your Honor, I did, right? And this is part of what you do when you're taking a plea. You lay down a factual basis for the plea deal. In other words, you can't plead guilty to something that didn't happen. They say, do you plead guilty to this DUI? You're like, no, I was riding my bicycle. I wasn't even drunk. Well, you can't plead guilty to that because they'll say, isn't it true that on or about this date in Arizona, you drove a vehicle under the influence? You say, no, that never happened. So then they could not enter the plea. So you got to make sure the defendant agrees to it. The judge is digging in. Then on November 29th, Cohen also pleaded guilty in a separate federal criminal case as to making false statements to Congress. Here's what he said back then. He said, in 2017, I was scheduled to appear before the Senate Select Committee on Intelligence, as well as the House Permanent Select Committee on Intelligence concerning matters under their investigation, including principally whether Russia was involved or interfered in 2016. Can you believe they called that guy to Congress? Michael Cohen to Congress. It just shows you how debased the whole entity is. In connection with my appearances, I submitted a written statement to Congress, including, among other things, a description of a proposed real estate project in Moscow that I had worked on while I was employed by Trump, right? That description was false. So this guy is so dishonorable and a liar and a convicted perjurer that he created a fake proposal, real estate project, and wrote a fake description for it, and then sent it into Congress. Okay, lied to all of Congress. That's how, first of all, dumb he is. He was being used as a tool, just like he's still being used as a tool. Sends that into Congress, and they all realize that's a lie. That never happened, obviously. And so he lied to Congress, and Alvin Bragg's like, perfect, that's our guy. We're going to put him up on the witness stand in this new Trump prosecution. Great. So the cases were consolidated for the purpose of sentencing, and Pauley, the judge, sentenced Cohen to 36 months in prison and a 3-year term of supervised release. Now, notably, Cohen was given full credit for his purported acceptance of responsibility, right? So Cohen got a benefit for this, and he received a below the guidelines sentence. If you don't accept responsibility, then the judge might say, well, you haven't learned your lesson, it sounds like, so you might need a little harsher of a penalty, you know? So Cohen comes in, yes, I was wrong, I'm sorry, mea culpa, you know, my fault, all the things. And he accepts responsibility, so he gets a benefit. Then after he gets the benefit, then he's like, no, that never happened. I never lied to anybody. Now, even before his sentencing, Michael Cohen, the liar, he began to minimize the seriousness of his decision not to report this millions of dollars. Now, specifically in connection when he was sending stuff over to probation, right? So probation's like, well, tell me what you did. Cohen, he said, all relevant bank records were provided annually, and Cohen repeated these efforts. He tried to blame his accountant. And that's not my fault. My accountant did it. Accordingly, to the government prosecutors at the Southern District of New York, okay, so DOJ entities, they said Cohen's statements were, quote, simply false, and the government was prepared to prove at trial that the limited information Cohen did provide to his accountant could not have led his accountant to cover or uncover the unreported income. So then in December of 2019, less than 1 month into his 36-month probation sentence, Cohen sought a sentence reduction, but the government, the DOJ, opposed that. They informed the judge that they had substantial concerns, right? The government prosecutors from the DOJ, they wrote this back in to the court. They said that prosecutors had, quote, substantial concerns about Cohen's credibility as a witness, based in part on lies that he made during proffers that included material false statements. So he is giving the government a bunch of information. They're all lies too. That was in January and February. And the government put this in writing, right? That's like they're quoting their own documents. The prosecutors also expressed concern, the DOJ, that apparent contradictions exist between Cohen's post-sentencing congressional testimony and his guilty pleas and his certain filings in the Southern District of New York, and a litany of public comments made by Cohen and his surrogates about his federal case, many of which minimized his acceptance of responsibility and were inconsistent with his guilty pleas and other disputed facts, all from their filings. You see this here. They cited this in their own document. Cohen repeatedly attempted to walk back his own guilty pleas. He said there was no tax evasion. That's a lie. A televised interview, Cohen came out. He described the role in one of the campaign finance charges. He said, I just reviewed all the documents. And Cohen's claims in litigation that all 8 of the charges charges against him, said that he was doing it on behalf of Trump and he had nothing to do with it, right? So the dude just lies constantly, and even the DOJ is calling it out. So if now Alvin Bragg decides that he wants to run with this witness, we got questions about that. Why are you running with a witness who's so disdained that even the prosecutors, even the DOJ, even they won't touch this dude? Judge Pauly denied Cohen's motion. He said, you did make, literally, a judge found this, made material and false statements in his post-sentencing proffer sessions, and that his and his surrogates and their ad hominem attacks against the prosecutors, it lacked any substance. And then in the following years, Cohen also filed several unsuccessful motions seeking early termination of his supervised release. In June 23 last year, he filing opposing one of Cohen's requests. Government prosecutors, again, they came out. They said that Cohen continues to downplay his conduct. They noted, they said, more recently, don't let Cohen terminate his probation early. Why? Because he's still lying, Judge. He lied and he's continuing to lie. More recently, before trying to end his probation, he falsely wrote in a book, this is the government writing this, these are prosecutors, that he authored, he said, I did not engage in tax fraud. It's weird because you pleaded guilty to it. That the tax charges were all 100% inaccurate and that he was threatened by prosecutors to plead guilty. Now, additionally, in a recent attempt to distance himself from the guilty plea to making false statements to a financial institution about his tax medallion liabilities, Cohen stated on TV, first and foremost, there was no fraud in the medallions. I don't even know what he's talking about. Now, Cohen's statements are belied by his under oath statements when he pled guilty, which included that he was guilty of tax evasion and false statements, and that he had not been threatened or forced to plead guilty. And they are evidence that Cohen has not taken full responsibility for his actions. Indeed, quite the opposite. As the government notes and stated previously, while Cohen is free to write and say what he wants, he cannot simultaneously distance himself from the conduct on cable news and cloak himself in claims that he accepted responsibility in court filings and got a lower sentence because of it. So they say remarkably, Cohen's most recent request for relief has been overshadowed. Oh, they're good. They're going to dunk on him for this. By revelations, by the fact that he caused his lawyers to cite magical federal cases that don't even exist. This is the Google Bard fiasco. On November 29th, counsel for Cohen, they sent a letter into the judge. Cohen said, and his lawyers, that his client had given unwavering cooperation, and he gave critical testimony, and he gave a truthful account of his experience in Tish's trial, and they demonstrate an exceptional level of remorse, and so his probation should be terminated early. Now, counsel also cited, this is Cohen's lawyer, remember this? They cited a bunch of case law. Weird. There were a bunch of district court decisions, amazing, affirmed by the Second Circuit that grant early termination of supervised release. Remember this? So Cohen, he sent all this case law. United States versus Figueroa Flores, Second Circuit 2022. United States versus Ortiz, decided also 2022, Second Circuit. And United States versus Amato, that's a Westlaw case, also cited in 2022, all decided by the Second Circuit, right? That's kind of your first idea that the Second Circuit decided all these in 1 year. That's pretty amazing. And all these cases are directly on point with my legal issue. Amazing. Second Circuit, like 3 back-to-back. Wild. And different months too. Anyway, so those were all made up. Now on December 12th, so Cohen just makes stuff up all the time, including with using technology. Judge Furman entered an order to show cause as to why sanctions should not be imposed relating to the 3 cases that were cited in the motion. The judge wrote back to Cohen, as far as the court can tell, none of these cases exist. Now in response, the attorney who filed the motion on behalf of Cohen informed Judge Furman that Cohen sent him the citations, right? The lawyer says, I got it from my client. The attorney asserted that he believed at the time that based on comments made to him by Cohen, that the citations originated from another attorney representing Cohen, but that he learned after the court's show cause order that Cohen admitted to his other attorney that he found the cases, quote, on Google. Okay. So Cohen's even lying to his lawyers. Cohen probably didn't want his bill to be, a lot. So he sends this other lawyer, hey, use these cases. The lawyer says, where'd you get them? Cohen says, from my other lawyer. He said, you look them up? Yeah, they're good. Okay, I'll put them in the motion. You want me to? Did you look at them? Yeah, they're good. Okay, put them in. Lying to his lawyer. He got them from Google Bard. Now, in a separate filing, Cohen didn't even want to take responsibility for that either. He tried to minimize it. He says, Your Honor, in a filing, he says, this is a simple case of a client making a well-intentioned but a poorly informed suggestion, trusting, as he was entitled to, that his attorney would vet that suggestion. So he sends him the fake cases and then blames his attorney for not looking them up, which is true. The lawyer signed that. I mean, you should look it up. But still, Cohen was a lawyer at one point. Moreover, I think Cohen asserted that his recollection differs from Schwartz and that he is certain that he did not tell Schwartz that Miss Perry would provide or had been providing any case cases of this sort. So clearly lying. Now, he said, yeah, it's clear once again that Cohen is lying. Cohen said, I tried to send this from Miss Perry through Cohen, and I spoke with Cohen via telephone, as I did frequently. On those calls, he reiterated to me that Miss Perry would be providing the cases. Again, dude is lying through his teeth. We also know that he lied at the trial. They say, Alvin, as you are aware, Michael Cohen also recently testified in the civil case. Now, during his testimony, he committed perjury by falsely testifying that he refused a motion pursuant to the law from the U.S. Attorney's Office. That's not true. And two, by testifying falsely that he did not commit the crimes that were charged in the original counts 1 through 6. Here's what it sounded like. Most notably, Michael Cohen, convicted perjurer, testified that he was not guilty of the federal tax evasion charges. And he also confirmed in trial that he lied, lied to Judge William Pauley during his sworn plea allocution in 2018. This included the following sworn testimony about the guilty plea. Question to Michael Cohen. Michael, liar. Have you ever made any public statements concerning the legitimacy of your convictions? More than one, he says. And why did you do that? Because there was no tax evasion, says Michael. At best, it could be characterized as tax omission, I have never in my life not paid taxes. That's not what we're asking. We're asking about all the taxes. I have never requested an extension until 2017. Every year I had paid no extensions on time, what my CPA accountant directed me to pay. So there was no tax evasion. That's curious because you pled guilty to that. Here's a question from Michael Cohen. Did you lie to Judge Pauley when you said that you were guilty of the counts that you said under oath that you were guilty of? Did you lie to Judge Pauley, Michael Cohen? Yes, I did. Yes. That's insane. You lied to a federal judge? So, sir, you lied at the time. You lied more than once in federal court. Is that correct? Correct. Now, when the stakes affected you personally, you lied, didn't they? Correct. And you misled a federal judge, right, Michael? Yes, I did. So Cohen then reiterated in public statements on the steps of the courthouse where the trial was due to take place that he repeatedly lied and he committed perjury. Now, at a bare minimum, Alvin, Cohen's testimony demonstrates that he has committed perjury either when pleading guilty to the federal charges or when recently testifying in New York that he did not commit the crimes to which he pleaded guilty. The truth cannot have it both ways. And so your office needs to know this. Even federal prosecutors responsible for bringing the federal charges against Cohen, they have represented to the federal court their belief that it is the latter, that Cohen lied in his recent court testimony. He lied in Engeron's court. Citing his recent testimony, the DOJ prosecutors, they opposed another attempt by Cohen to terminate his probation early. They say he appears to have lied under oath in a court proceeding. The prosecutors also say they have evidence to prove it. They said, to be clear, Cohen was guilty of tax evasion over a period of years. He pled guilty to it, purported to take responsibility for it at his sentencing, and he received credit for that, for even accepting responsibility. And the government had sufficient evidence to prove him guilty of tax evasion beyond a reasonable doubt if he had gone to trial. Now, after admitting to multiple past instances of perjury before both courts and Congress, Cohen once again committed perjury right in front of Judge Engeron, right in front of him. In response to questions asked by the Attorney General, Cohen first claimed to have been specifically tasked by Trump to increase his total assets and to falsely inflate the total net worth. And Cohen doubled down on this falsehood when confronted with his previous testimony to Congress that he did not recall ever being directed by Trump to inflate the numbers, claiming that he lied under oath to Congress in that instance. So he admitted, right? Cohen says, Trump told me to inflate the total assets. When somebody asked you about that in Congress, you said no. So were you lying then or are you lying now? Shortly thereafter, Cohen reversed course and stated that he in fact did not lie to Congress. He then admitted he lied earlier. No, I lied to you earlier. And I admitted that President Trump never actually told him to falsely inflate his assets. Crazy. Now, yet despite all these admissions of perjury and despite his blatant perjury during that trial, and Engeron said he was believable, you have refused to even investigate, much less prosecute Cohen, and you plan to fully call him as a witness in your upcoming criminal trial? Your office has indicated that you intend to call Cohen as a witness. Now, Cohen will presumably falsely testify yet again that he did not commit the tax evasion crimes to which he pleaded guilty in 2018. He may even try to shift blame to federal prosecutors for charging him with bogus crimes. And based on this, we urge you, Alvin, to remove Cohen from your witness list and do not commit a new crime. Avoid the illegal act of suborning perjury. Don't put a liar on the stand because you could be in trouble for that. Now, as officers of the court, prosecutors are charged with the duty to ensure that evidence is truthful. And this includes an obligation to prevent lies from coming out on the stand. You're held to high high standards. You have a lot more power. It's fundamentally unfair for a prosecutor to put a liar on the stand. Saying these issues, Alvin, demand careful consideration because of the legal, ethical, and the constitutional issues they implicate. We again urge you to reconsider your positions regarding Cohen and Mr. Weisselberg and put an end to the selective and oppressive misconduct of your office. In addition, because of the manner in which your office has selectively leaked information you deem favorable, we are going to be making this public, as they have done, enabling us to read it and enjoy it. A very good letter that just shows what a double standard here exists, signed by Todd Blanche and others, Emil Bove and Stephen Weiss from Blanche Law, attorneys for Trump, going over to Alvin Bragg at the DA's office in New York County. And as you can see, the double standard exists. Michael Cohen is a liar, lied multiple times, lied about lying, then reversed his lies. You can't keep him straight, and he's going to be their star witness. Meanwhile, they are prosecuting Weisselberg, who is on Trump's side, to take him out of the entire equation. And as we saw, a lot of that was based on the civil case, the underlying fraud prosecution that was brought by Tishy Tish. And Alina Habba is saying all of that is on appeal anyways. So in other words, where they're claiming Weisselberg lied and how the testimony played out, the entire Engeron case is on appeal. So the question is, are we going to be undoing some of this in some way, shape, or form? Alina says we're appealing it. We're feeling good about it.
And the last one, your case in New York, where judges said $465 million, you got to come up. I think Trump petitioned the court to say, can I come up with $100 million? And I believe they said, where's that stand? Let's just ask you that.
Sure. The Attorney General case is on appeal. We're waiting on that decision. We had a good hearing last week on that case. Obviously, the judge, the appellate division, saw that there were some issues in the order and rectified them. I've said this a million times. I think our appellate case is going to be very strong. We have a good record for appeal. We know that there were decisions that were made in error. We know that there was an appellate division decision that narrowed the statute of limitations, which was completely ignored in the trial court. Like I say all the time, honestly, it's time to let our side come out and for the American people to be patient and see what happened today.
So Alina says that they're looking good. Their appeal will be working its way through. And of course, this is New York, so things are historically not good there for Donald Trump. Remember the E. Jean Carroll saga? We had two different hearings or trials on that one. We have, of course, Tish James, and now we've got the Alvin Bragg prosecution. So Trump sends the open letter. I do not believe that Alvin Bragg is going to voluntarily dismiss Cohen in any way, shape, or form. But now the public can know how bad of a witness he is and that this guy's going to make up the crux of the entire case. It's all set up to go after Trump. It is now being accelerated because the other trials are being delayed. This case was originally not even anything that we were worried about this year because Alvin admitted that the other trials were going to go first. But now that the other trials are all falling apart, Jack Smith is failing, Fani Willis is majorly failing, they've accelerated this. They know this case is very weak. They know Michael Cohen's a terrible witness, but it's New York, so who cares, right? As long as they get the right jury, it's going to be a difficult hill to climb, and they just need a single felony conviction before the trial, I think, to get their political victory. And it's going to be less of a victory until the Supreme Court came out with that opinion yesterday saying that only Congress can disqualify somebody on an insurrection clause, although this is not an insurrection case. One theory was that a felony conviction would be parlayed into some other consequence that they could try to use to disqualify him from the ballot. But interesting development. Now, trial is right around the corner, my friends. This one is looming. It's on deck. So thank you for subscribing wherever it is you're watching this. Thanks for joining us as we continue this coverage, not only in this case, but all of other Trump sagas that are currently afoot. We would love it if you checked out some of the links in our description box below, including our locals community at watchingthewatchers.locals.com, including robertgovea.com, where you can get and access all the PDFs that we are going through here today. And we'd love to see you back here joining us on the next one.